Oh, today we're talking about inconveniences that can be caused to us by our neighbors. The situation when we are not happy about noise, about some partying, music, about the behavior, social habits, whatever, of our neighbors. Of course, there are different degrees of that. It might be just some long-lasting and toxic construction going around, or it might be just some neighbor's behavior. And all in all, the recourse that we are getting from the Civil Code of Quebec about that is the famous Article 976, which tells us that the Civil Code obliges all the neighbors to tolerate each other to a certain level, to a certain reasonable level, let's put it this way. The idea is that you have to let your neighbor to enjoy his property or her property in the same way as the neighbor has to let you enjoy your own property. So the question is, what is this level? At what point this disturbance, this annoyance that you get from your neighbor becomes unlawful? So when can you complain, when you can demand something, when you can maybe sue? Well, if it's really necessary. One of recent judgments, from which the appeal was dismissed in 2022, so now it's final, repeats again some general principles that are usually applicable in such a situation. And to take it brief, there are 2 points that should be observed in order to make this disturbance beyond the lawful limit. First of all, we should remember that it's sort of an objective test, so-called objective test, meaning that the intention of one party, the one who is disturbing, is not that much important. It's so-called strict liability. So the objective disturbance is taken into account, not the intent of the party to disturb or not to disturb. And on the other hand, it's not a subjective perception of the disturbed neighbor, but like a imagined, I would say, reaction of a standard, average, reasonable person in such a situation. That's what taken into account, or should have been taken into account by a judge, by the court, to verify. So these 2 things, these 2 approaches taken together, show that it's not whether the neighbor is bad or is going to do something bad to you. It's not whether you perceive something as offense, as something bad towards you, which is important. But if it's subjectively, the disturbance is beyond certain level, whether the neighbor wanted it or not, and whether this disturbance is really a disturbance, whether you think of it as one or not. So one thing to verify is the question of recurrence. Is it just one-time episode, or does it happen regularly, or at least often? And at any moment, does it happen regularly, at least often, to the level of a disturbance from this objective point of view? And second part is gravity. So the actual threshold that we're talking about, what is it? And to summarize this long text, basically the court says that simple discomfort is not enough. It should be really intolerable from an objective point of view. Basically, it should render your property almost unusable, at least the enjoying your property should be almost impossible. So the threshold is actually really high. That's why usually this article, at least most often, this article is used in cases of some industrial disturbance around, and not so often when it comes to just your regular neighbor around. So, to summarize, in a regular situation, even if you do not like some noise going from your neighborhood, if you don't like the music, if you don't like the party shouting or whatever, it's not enough to claim that your neighbors are doing something bad against you, against your property. It should be recurring, it should be grave enough to invoke this famous Article 976. Otherwise, it's our obligation to tolerate. Thank you and have a nice day.